Thank you, ladies and gentlemen, for joining us for another edition of the Free Exchange of Ideas with Donovan and John. We are here to help you out. Now, let's just get to it.
Here we go. Hey, thank you for coming back again to Free Exchange of Ideas with Donovan and John. Today we're going to talk about the Fifth Amendment. It's a lot deeper than a lot of people realize. A lot of people really just associate the Fifth Amendment with the right to stay silent and not respond to questions from the police or others. But it's actually a lot bigger than that. There's a lot more involved. And the reason we did the 14th, pardon my reach, the reason we did the 14th is because the 14th and the Fifth Amendment both have I almost said establishment clause. That's wrong. I apologize. I thought I had this right in front of me. Oh, due process clause, right. I just had it. And so that actually makes it like doubly strong because they put it in two different places. So, and the 14th Amendment is what, like 50 years after the Fifth Amendment? The first 10 amendments, I guess, actually 50, 60 years after. So I think that makes it even stronger to tie all of it together. At any rate, so Donovan's going to go ahead and read the Fifth Amendment, and then we'll just discuss it. I think is probably the best way to go from there, clause to clause to clause.
Yep. So, okay, here we go. The Fifth Amendment in its entirety. A lot in one sentence.
Right.
No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
And that last one's even more important, but we'll get to it, I promise you. So the clauses incorporated within the Fifth Amendment outline basic constitutional limits on police procedure. The framers derived the grand jury's clause and the due process clause from the Magna Carta dating back to 1215. So people were thinking about this way long before we got anything rolling. Scholars consider the Fifth Amendment as capable of breaking down into the following 5 distinct constitutional rights: the right to indictment before a grand jury before any criminal charges for felony crimes. I'm sorry, it says felonious crimes. 2, a prohibition on double jeopardy. 3, a right against forced self-incrimination. 4, a guarantee that all criminal defendants have a fair trial. And 5, a guarantee that government cannot seize private property without making a due compensation at the market value of that property. Now that one's like super important to me because right down the road here in just outside of Salinas, Prunedale, there they decided they wanted to build an overpass and new ramp. They had to widen the area of the freeway, and they were going to take this guy's land. And I mean, he fought them for years because they weren't making a fair assessment, and he didn't want to lose the land. That was actually that area of land that he had was where he grazed his cattle, and he had a couple thousand head of cattle. So it was a lot of grazing land that they wanted to cut out of his ability to keep cattle. And he knew that that would cost him, I think it cost him basically 500 or 600 head. He couldn't graze anymore because he didn't have the land. He didn't have the room. He couldn't buy behind him. There was somebody behind him and there was no place to go left or right. So when they pulled that frontage out of him, he just lost that land. It took several years and the government finally did win their case, but they paid him a more reasonable sum of money for the land and the loss of future revenue because of the loss of grazing land for his cattle. So he made out okay, but I mean, even from the beginning, it was pretty much a done deal. The government was going to take the land to make this big loop on-ramp, off-ramp thing. So there's a push and shove there. He got fair compensation. He got fair compensation for loss of income, but he lost the land. And so I think, and it cost him a lot of money. I mean, he spent a lot of time in court fighting this. So, and I don't think he ever got that money back. That's just money down the drain in essence. But what they
Well,
were
it's not down.
offering,
He
what
won technically, right?
well,
Mhm.
yeah, no, technically he lost because the government did get the
Yeah,
land.
yeah, but he got more money than they originally offered.
He got quite a bit more money than they originally offered. Yeah, due to the court system.
Yeah.
Um, but that's actually the last clause of the Fifth Amendment. And like I said,
Yeah.
the Fifth Amendment is a very deep um, amendment in that there's a lot of stuff in here that is really, in essence, anti-government. You don't have to uh, self-incriminate. Um, and in this, they've also turned uh, your spouse can't be forced to incriminate you for anything either. And that's a big thing too, as well, in my opinion. You have any cases you want to talk about, Donovan?
I would differ with your wording of it's anti-government as it is pro-individual rights is how I would describe
I would go that way. Yeah,
it.
I think it's kind of a little bit of both. I mean, for me, the entire
Pro-individual protection, things like that. So
yeah.
not necessarily anti-government because this is part of the Constitution and you're using the Constitution to
Well, I
defend and
just mean
protect.
in that it limits what the government is allowed to do. Unlike, and I think they're really working on the premise that, unlike the king, we don't want anybody to just walk in and grab our shit or tell us we did something when in fact we did not, or whatever.
And it puts the onus of burden of proof on the government, things such as
Yes.
that. So compare, and that's as one of the videos I was listening to was how they're talking about the Magna Carta and how things, and I think even until 18th century England, they were still doing some pretty brutal things to people in custody without necessarily, proven of guilt.
Exactly.
So, but it was so that was I got kind of the same notes you kind of went over here. The main one's Miranda. I didn't really go into Miranda other than it was.
Well, that's a great case. That is a great case.
1966. Ernest Miranda. Apparently, he was, not battered. I don't know if he's battered physically or not, but battered, overtime hours, being questioned before admitting to the guilt. Before admitting guilt, I'm not even sure if he was guilty or not. They didn't even talk about that.
He was found not guilty later.
He had low IQ and things such as that. And they brought the case, to the Supreme Court, and they were saying, you have to be informed of these rights, and that's kind of what set up, the right to remain silent that we all know pretty much by heart now. So,
what year was Miranda? Because that's kind of important too.
If there's anything I learned, use that right.
The first thing any attorney will tell you in dealing with police is shut your mouth.
Have you been drinking? I plead the fifth.
Yeah. Unless I ran into a tree, why would you ask me that, officer?
But so other than Miranda, which is the big one, I didn't even hear any other cases mentioned for that. I don't think. But Miranda versus Arizona, Ernest Miranda, 1966. You do not have to take the stand. You do not have to help government. You don't have to answer the government's questions or by police. So we're kind of skipping around. That's the third clause, or it's not a clause. What did they call it? They called it a.
Yeah, it's a clause.
The clause, okay. So yeah, invoke the right to remain silent. Invoke the right to an attorney. I do not consent to any searches. Those are like three of the most important things you could say to protect yourself when dealing with enforcement.
Well, and actually, that goes back to Fourth Amendment. No illegal searches and seizures, to be secure in your person papers and places.
I do know one. They were talking about the block murder rule.
Yeah.
So that was the other one. You can only be tried for one crime if the crimes are tied. You can't be if you murder three people, you can't be tried for one murder, then another murder, then another murder. So
it's funny you bring that up. I was just listening to a podcast on a case where a gentleman was had robbed a store or something. I forget the exact thing, but he'd taken. Oh no, it was a storage facility. He had broken into 10 different storage lockers, and he'd done it by he broke into one from the outside, and then he broke through the drywall to get to the rest of them. So they're all tied together, right?
Yeah, obviously,
Well, the original case was they tried him for 10 separate crimes, and his attorney had to go to the state. Was it Missouri? It might have been Missouri, where they eventually went to the state Supreme Court, and the state Supreme Court said, no. These all happened in the same time, so it's one crime. You can only try him for one crime. Because what they had done is they tried him for 10 crimes, and they stacked the sentences. So, and they didn't even give him concurrent, they gave him consecutive. So they're bam, 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 bam. I mean, he was looking at like 65 years for, in essence, grand theft. And it wasn't that grand a theft, if I recall the numbers. But yeah, so this clause is really important to that as well.
Yeah. So, and then you were talking about like grand jury, for infamous crimes, federal crimes, felonies. So they're non-selective. SCOTUS hasn't, it's not in the Constitution that states have to do this. So some states have grand juries, other states have preliminary hearings.
Right.
They obviously don't apply to military trials, which is stated.
No, military and some other level of militia, military, and some other level of government, I think.
So, land or naval forces or militia.
Yeah, right. That's what it was. Land or naval.
Basically, yeah. Service within actual service in time of war. So basically, military trials are.
Right. Well, when you join the military, you fall under what's called the UCMJ, or Universal Code of Military Justice, and that does not allow a lot of the rights from the Constitution, because it originally was built under maritime law and military law, and that law comes out of England and France, I believe, the basis of those laws, because they had and Spain probably, because they had the 3 largest navies on the planet at the time. So, I mean, some of that might have come out of Roman military law as well, because that was pretty stiff stuff. At any rate, so yeah, the grand jury thing, that's kind of a big deal, because that requires that there's a lot. It's not just preponderance of evidence. There has to be some rock solid stuff for you to get indicted.
Before you're indicted or arrested. So
yeah.
So the notes I have here is that the grand jury listens to the prosecutor and evidence. Now, the one thing that I thought was interesting that I learned was there's no exclusionary rule. So if there's evidence that was obtained illegally, that can be used in a grand jury.
Yeah. The nice thing about the grand jury, though, also is that everybody that's on the grand jury, and I think it's like 11 to 17 people.
I think they said 23 when I was listening.
23. You're right. I'm sorry. Can ask
questions. There's no actual number. So
right. But they can ask questions of the prosecutor and witnesses to clarify. If something sounds a little hinky, they'll call it out. There, for the most part, you find people on a grand jury that are pretty well versed in what is law, amazingly enough, because a grand jury is drawn from the general pool of population.
I would love to be on a grand jury, or I would just love to be on a jury.
Yeah.
I would love it.
I actually was looking at volunteering, because in California, grand juries volunteer, but they serve during the day, and my job is during the day, and so I couldn't serve, which kind of sucks, because I really do want to do it, but evidently I have to be retired to do it. But yeah,
now 60-year-old boomer.
in California, I think it's 23, like you were saying, and
some states have grand juries, some don't. They're calling preliminary hearings too. I guess that's
right.
So
yeah, and I don't know about those.
I don't know what states have what or
right.
not, but they usually call a preliminary hearing. But some states, I think California has grand, like you were just saying, has grand juries because that's where I've been from.
Yeah, we actually
I don't
have
know about- I don't know about
several for the
Colorado.
counties. They're county grand juries basically, and then there's a state
So,
grand jury. But yeah, so that's really really cool. Deeply rooted in Anglo-American tradition, the grand jury was originally intended to protect the accused from overly zealous prosecutions by the English monarchy.
yep.
I did not know that. That's kind of cool. In the early phases of the development of the U.S. Constitution, the founding fathers had decided to retain the grand jury system as a protection against overzealous prosecution from the central government. Although the Supreme Court in Hurtado v. California in 1884 has refused to incorporate the grand jury system in all of the states, most states have independently decided to retain a similar form of grand jury, and currently all but 2 states, Connecticut and Pennsylvania, have the grand jury. That's pretty cool. So now you know, don't screw up in Connecticut or was it New Jersey was the other one? Pennsylvania. Wow. Sorry, Pennsylvania.
I'm sure they got something in place. Yeah, that's all I had for that. So preliminary hearings for states. Yeah. So
Okay.
Second clause, which we talked about, too, double jeopardy. You're only on trial for once. We're talking about the block murder rule. So yeah.
I think we should kind of delve into that one as well, because that's double jeopardy is huge, and it is a protection that we absolutely need as citizens. Now, right now, currently, Jussie Smollett has been was convicted of 4 felonies, I think, 6 felonies, 6, and was put in jail for to serve 150 days. He has recently been released by a appeals court because his attorneys are saying this was double jeopardy. He'd already been accused and arrested on these charges, and the charges were dropped by the then prosecutor, Miss Fox. I don't recall her first name. I apologize. And then they were dropped, and he had to pay a fine, or actually, he just donated his bail money. And the new prosecutor came in and said, no, that's not going to fly. He's not going to walk away from this. He did some serious damage to not only his reputation and his career, but to the idea of Black Lives Matter. Was the jury's and the new prosecutor's thought process. So they did take him to jury or to trial on those charges, and eventually gained a conviction of 6 of 10 or something like that. And his 2 buddies are going to jail as well. They are not out on any kind of bail or anything. So wait to see how that plays out. I'm interested to see how that plays out, because I
haven't been keeping up with that. Sorry to interrupt you.
No, that's okay.
Other than I hear about it in the news, but I haven't really been following.
Well, this literally happened like yesterday morning. So
okay.
Yeah. So
I'll check it out.
Yeah, I am really interested in that, because I'm really not sure how they're applying double jeopardy in that charges were originally dropped. So he never went to trial.
He never went to trial. Yeah. So that's kind of probably how they got around it.
I think that's how they're going to get around it in the next step up court, in the appeals court. But we'll see. I was surprised that they released him from jail, and that may have a time thing on it, because it may take longer than the 150 days or even more than 30 days to get this trial rolling and completed, just because of the calendar.
And I kind of see that, and it's kind of like, oh my God, what's his name? Who's the billionaire guy? Died in jail. Pedophile.
Which one?
Pedophile, New York.
New York? Yeah, he didn't commit suicide.
Whatever. Hung himself.
Yeah. No, I know who you're talking about. I'm sorry, I can't think of his name. Jeffrey Epstein.
Epstein, Epstein, made that deal with the prosecutor at the time.
Saying, in Florida. I know what you're talking about now. Yeah.
And the new one came in and said, no. So another guy came in. So, and in a way, I think that's kind of messed up.
Because you got the deal.
yeah, you make a deal and you think you're good, and then all of a sudden someone new comes in and says, "No, I'm not going to listen to that anymore." So,
Yeah.
I don't know. I'm not saying he wasn't a bad person or anything like that. I'm just saying in general, when you do something like that, you think,
You think it's a done deal? I can walk
yeah, you
away
think it's
from
a done
this.
deal. So yeah, so
Yeah.
I guess I have some issues with that. The same thing. And you're talking about double jeopardy. We look at Cosby too.
Right.
Who was released, and can't be tried again. Technically, I guess is
Are they
he
going to try
can't be
him
tried
again?
again,
I
right?
didn't hear.
And no, I said I don't think he can be tried again, right? So I
I
mean,
don't think so, but yeah, I don't. I know they're bent out of shape about the vacate.
I mean,
Did they
I guess there
vacate
was some
the?
technicalities on it that he was
Yeah.
released on, and
Yeah, there was some
there might have been.
technicalities
I'm
on
not,
it.
and I have not followed that case at all
No.
by too much, other than what I just kind of saw on the news really quick
Right.
on that. So I'll take a look at that. Maybe put a link for that as well.
Yeah, that'd
See
be
what's
good.
going on. So yeah, because I don't know. It'd be interesting to see how that worked out. But I know it was he got off on a technicality, and he was released from that. So now, having been convicted of that, he was still convicted and in prison. So I don't see. To me, that sounds like no, he can't be tried again. To me,
I don't. Yeah, I don't think so. But I don't know if they vacated the charge. I mean, if they vacated the conviction or if they just released him.
yeah. I'll look that up. I'll look that up and find
Okay.
that. So that's
Yeah, 'cause
another one I was thinking
I
of.
bet.
The Epstein and the Cosby cases are
Yeah,
two
I bet that's
cases.
a deep. I bet that's a pretty deep dive. The
So
Cosby thing.
yeah. So, but it's and then as feminists were up in arms about it as well. But not. And I'm a feminist ally, but there's still like rule of law, and sometimes rule of law has technicalities. So I'm not. That's what we hire lawyers for.
Right. Exactly.
So yeah, so it's not, I won't say it's a perfect system by any means, but it's the system we have. So yeah, so double jeopardy, block murders, if crimes are tied, must be tried at once at one time. So mistrials, new trials, if it's a mistrial, you can get a new trial if it's a mistrial, unless it's something to do with the prosecutor or something like that.
Well, then it's not a Well, yes, it's still a mistrial, but
Yeah.
like in the Kenosha, what the hell is that kid's name? I
I know
forget.
you're talking about.
Yeah, I forget his name and I apologize, but they were talking about a mistrial pretty late in the trial because of prosecutorial misconduct. However, I think the judge did not want to do that. I think he just made the threat a couple of times to settle the prosecutors down. It worked. But yeah, if he had made it a mistrial, then I think, and depending on how far they go with the prosecutors in that misconduct, they could still refile. They would have to refile the case if they wanted to refile it. But they have like a small window to do that. So I mean, you have to have your ducks in a row before you really go to trial the first time to make sure that doesn't happen. And they
So if you
did.
look up Kenosha killer, it's Kyle Rittenhouse. So.
That's funny because he's not. Well, I take it back. He's a killer. He's not a murderer.
So.
And I know that's a fine line. And I know a lot of people are going to disagree with me, but he was found not guilty. So that's the end of that, in my opinion. Anyway, so yeah, let's go back to the self-incrimination thing because I really do want to talk about how you use that, how you're allowed to use that, and how you're not allowed to use that. Self-incrimination is a very important thing when you're on trial. If you are on trial and they call you to the stand, I don't know what the procedure is if you decide that you are not going to be called to stand by your attorney. I don't know if the prosecution can call you outright. But once you get to the stand, if you answer a question besides identifying yourself, you can no longer stand on the Fifth Amendment, is my understanding of it in federal court.
You're basically taking the stand. So
Well, yeah, but if you're called to the stand by the prosecution, I think you still have that Fifth Amendment right.
Yeah, yeah, you can still go to stand and say I plead the fifth, obviously.
Right, right. But if you answer a question or two, you can no longer stand on the Fifth Amendment. Now you have to answer questions. I don't think there's a limit to how many questions they can ask you and you can answer before you can say, no, I'm not going to answer any more questions. I think you have to do it right in the beginning.
Yeah, and the one thing too that I was listening to is that I was saying pleading the fifth doesn't admit guilt. So
right.
you know,
And see, and that was one of the misconducts, the prosecutorial misconducts in the Kyle Rittenhouse case. Was the prosecutor brought that up when he was asking, why did you not talk to the police? Why did you stand on the Fifth Amendment? Well, you can't ask him that in trial. You can't bring that up in trial at all. So, and the judge jerked his chain on that like almost immediately. Because I thought you couldn't ask him that, but I didn't know that for certain. Now I do, at least in Wisconsin federal court.
Yeah, and then the other thing that came up on that when I was listening to it was the Hewett Trials. So you know,
which one's that?
McCarthy, the Hewett Trials.
HUAC.
So, yeah, so you know, the Un-American Activities Committee.
Oh, right. Sorry.
House Un-American Activities Committee.
Right.
So how these accused communists were pleading the fifth and using the you know, the Constitution to defend themselves. So yeah, so that was interesting too. That was one of the big ones.
And see, and that's something that I think people
Fifth Amendment commies is what they were called. So
right, and I think that's something that people don't recognize. Just because you are a communist or Marxist or whatever, it doesn't really matter. Black, white, green, or purple doesn't matter. If you are in the United States and you are in a courtroom in the United States being prosecuted, you have all the rights and responsibilities of a citizen in court.
Yeah. The other note I have is once you're detained, you must be informed of these rights. Though I want to say there was a recent trial within the last few years saying that they don't have to do that anymore because everyone knows them, which I don't know how I feel about that.
I haven't heard that. I'll have to look that up because I think Miranda, the funny thing about Miranda for me is that it's in the Fifth Amendment. It's clear in the Fifth Amendment that you can't be forced to self-incriminate. However, they had to codify it for police. That doesn't make any sense to me, but that's what you have to do sometimes to make sure that authority understands their own limits. And in the United States, there's a lot of limits on authority that are ignored on a fairly regular basis. But overall, for me, this is still one of the best legal systems on the planet. I would not be afraid to go into. I didn't hear you.
I said the best money could buy.
Yeah, I personally would not be afraid to go into this legal system because I pretty much track everything I do anyway. But and I don't do anything I think I should be worried about. There's not a lot of people that look like me because I'm short and round and white as a drywall. But but yeah, I just don't have that fear. I recognize the authority, and I've been in the court system on more than one occasion, and still don't have that fear. Yeah, I've never spent any real time in jail, but I suppose over my lifetime, over my 60 years from basically the time I could drive a car to now, I think I've spent less than a month in jail. And that's, I mean, honestly, that's not a lot, but I know a lot of people that can say they've never spent a minute in jail. I was a dumb kid for most of that, to be perfectly honest, and a dumb young adult. So sometimes you just do stupid things, but if you pay attention, you understand your rights, you can walk through the system and probably come out the other side okay. As long as you don't kill somebody.
I know one of the things me and you have talked about is talking about one of my recent run-ins with the law was that, the law, the judicial system is not set up to help you. The judicial system is set up to punish you. So,
well, and so is law enforcement.
yeah. So,
As a matter of fact,
they're not there.
they're taught in academy, we're the enemy, which doesn't make any sense to me. However, two things the Supreme Court has done that I really frown on, and really hope that in this next couple of sessions they revisit them. One is qualified immunity. Police have qualified immunity, and what that means is a trained officer in that same police department would do the same thing that the officer who should have his immunity removed did. So I think that's where the thin blue line kind of comes from, in my opinion. Also, lost my train of thought there. Damn, dark tunnels.
Well, I'm gonna cut in there.
Absolutely.
So one of the things I like about Colorado, and I talk about people with this too, especially in California, is I talk about how liberal Colorado is compared to California. People think of California as being a really liberal state, and I, as having lived there for 34 years, tell you it's really not a liberal state. It's not as liberal as people think or make it out as, compared to Colorado, which Colorado is the first state in the union to end qualified immunity for police here in the state of Colorado.
Oh, so, did they?
Yes, the first one. So yeah, so and I have to agree. I think you talk about not just the thin blue line, but you talk about the protecting, and there's and it's funny. I was just reading about this too. Just let's see if I can find the article. I'll send it to you personally, not connected to this necessarily, but about law enforcement. Oh, I know what I was reading about. It was the Orlando Police Department was basically kicked out of a national program, basically training police officers to, basically, so if you see a police officer doing something wrong, you call them on it and you're protected. That police officer is protected from retaliation, stuff like that. Orlando Police Department was recently just kicked out of that program because they retaliated against a lieutenant who basically told on the department that they were changing the curriculum from what it originally. So they were basically, the Orlando Police Department was kicked out of the program, which I'm blanking out the name of it, but I'll say, actually, I do have the article. I'll send it to it so we have that connected.
Okay. The other thing,
so Colorado is the first state to end qualified immunity for.
That's cool. I did not know that. That's awesome.
Colorado a lot more liberal than California. Also, we also kind of a tangent. We have a gay governor, so
that's definitely a tangent. The other thing that the Supreme Court has said. I remember when I grew up in Los Angeles and Southern California, every police car had to serve and protect on their doors or on their trunk. Every police car I ever saw. The Supreme Court has said that's not their job. Their job is not to protect you from being mugged or murdered or whatever. Their job is to find the perpetrator. So, wow, I'm going to have to change that background. I'm starting to blend into it.
It's a talking head.
Right? So when you think of an officer pulling you over and you ask him why he pulled you over, and he says, I'll tell you that after you give me your information. You can say, no, you can tell me first, because if you don't tell me, if I don't know why you pulled me over, I don't see a reason to give you information. It's not a legal stop to me. Now, you can make that argument, but you better have the stuff in your hand just in case.
One of the things I was researching while researching the Fifth Amendment was that you do have to hand over identification, but you don't have to answer any other questions.
Depends on where you are. California, New York used to be stop and frisk, right? And was stop and identify as well. The Supreme Court says, no, that's a Fourth Amendment thing. You can't just stop somebody on the street and ask him for his ID. You have to have
just cause.
Well, yeah, but you have to have articulable suspicion of a crime. I either have to have committed one, am committing one, or you think I'm going to commit a crime. And you have to tell me what that crime you think is. And it has to be justifiable. As a matter of fact, I just saw a video of a guy who got harassed by police, and he was convicted, and then the upper court said, no, they didn't have justifiable cause. There was no cause. There was suspicion, but not suspicion of a crime. He was just a suspicious individual. He was videotaping I think it was an Indian casino or Indian, no, not casino, oil refinery on native land. But he was outside of their border, at least as far as the thing was, because the refinery was in town, so it wasn't on Indian land, but they codified it so that their thing was part of their reservation.
Reservation. Yeah.
But the sidewalk outside of it was the city, and that's where he was, and that's public land. He can film or videotape anything he can see with his eyes. He says the only way to keep me from doing it is build a 30-foot wall. But if I go to Google Maps, I can see your entire thing. So there's no issues here. Well, the police arrested him and then all that crap. So you have to be ready and willing to if you want to stand on your rights, you have to be willing to go to jail to make sure you do. Because you might have to go through 2 or 3 courts to get them, properly codified. At any rate,
All right, you want to move on?
yeah, I think so. I was going to talk about Miranda Rights, but if law enforcement fails to honor these safeguards, courts will often suppress any statements by the suspect as violating the Fifth Amendment protection against self-incrimination. Now, that's really important because it becomes, in the eyes of the court, becomes fruit of the poisonous tree. It's the same as if a cop comes into your house without a warrant and finds your handgun and finds out that handgun, through their investigative services, is tied to a murder. If you didn't, but because they came into the house, they didn't have a warrant, wasn't in plain sight, they didn't have a reason to bum rush your house, that gun is no longer part of their investigation. It's thrown out. So that ends their investigation because it's the only thing they had, kind of thing. Pay attention to these little intricacies of law because they will save your butt. Next is
Due process.
due process. Due process is monstrous, and it is truly the thing that will save your butt. Am I up to it? Where? Oh, there it is. Sorry about that. I zipped past it too quickly. You got something on it, right?
Yeah, I don't have as lot like you make it sound, but yeah, other than it was repeated in the 14th Amendment, obviously.
Right.
But it basically sets up due processes and it sets up procedures and trial, and basically everyone agreeing to the same rules of law that are going to be used. Yeah, so so you must be informed of those rules and laws and the procedures when you're being detained or incarcerated or whatever, and they must be specific. They can't be vague, like, you're a bad person and we're going to arrest you for that. You need something specific for
right.
what you're doing. So, and the other thing was, I guess this may be what you're getting at, is they were talking about substantive democracy. Basically this go to, the Supreme Court could say something like, examples, privacy. We can't take away you can't be taking away what you're doing in the bedroom because that's your private thing, without take away that liberty without due process. So there's got to be, you can't just, attack those things or take away those things without due process. So,
right.
There's got to be the reasons why. So that's basically all I had on it. I don't know what you got on it, so let's hear what you got.
I was going to say, I just want to read this last paragraph here. Due process essentially guarantees that a party will receive a fundamentally fair, orderly, and just judicial proceeding. While the Fifth Amendment only applies to the federal government, the identical text in the 14th Amendment explicitly applies this due process requirement to the states as well. So no matter what courthouse you walk into, no matter what cop you're talking to, shut the hell up. And it applies. Courts have come to recognize that 2 aspects of due process exist: procedural due process and substantive due process. The procedural due process aims to ensure fundamental fairness by guaranteeing a party the right to be heard, ensuring that the parties receive proper notification throughout the litigation, and ensures that the adjudicating court has the appropriate jurisdiction to render a judgment. Meanwhile, substantive due process has developed during the 20th century as protecting those substantive rights so fundamental as to be, I'm sorry, let me just
They're
start.
not expressed in the Constitution necessarily.
Yeah. Substantive due process has developed during the 20th century as protecting those substantive rights so fundamental as to be implicit in the concept of ordered liberty. That's
Privacy.
yeah, that's mind-blowing stuff. That one, this is being thought of in the late 16th century, 16th, 17th, 18th, the late 1780s. At any rate, that these things are being codified in a document that is going to be the living document for millennia, for a nation,
Yeah,
to
and
build
it's
a
interesting to
nation
see.
on.
I mean, we do have like the oldest constitution in use in the world.
Democratic
right now.
Constitution,
So,
yeah.
yeah. So there's I mean, and there's obviously amendments to it, so obviously they can be changed. But it's interesting to see that we still have that.
I think it's important to say that too, because we've tried to build other nations using this template, and I don't think you can really do that if you don't have common ground to work from. There are people who have ideas of liberty, but even those ideas are limited, and this document makes the limits not on your liberty but on the government.
Yeah.
So,
all right, moving on. Last clause, which we kind
just
of talked about.
compensation clause, yeah.
Or the taking clause. The taking clause.
Yeah, I have just compensation clause, but I think it's the same thing. Yeah. In 2005, in Kelo v. City of New London, the U.S. Supreme Court had rendered a controversial opinion in which they held that the city could constitutionally seize private property for private commercial development where the redevelopment would economically benefit an area that was sufficiently distressed to justify a program of economic rejuvenation. And that is
private domain that benefits the public domain. So.
Right. This is 545 U.S. 469, 2005. However, after the Kelo decision, some state legislatures passed statutory amendments to counteract Kelo and expand protection for the condemned, meaning condemned areas, not condemned people. Condemnation by redevelopment, authorization of Fayette certain land into Brownsville Borough v. Redevelopment Authority, 2016. Nevertheless, Kelo remains a valid law under the federal context, and its broad interpretation of public use still holds true under the federal protection of the Fifth Amendment right to just compensation. So there is some stuff. I remember, I want to say New York, there was a neighborhood that was, Detroit, so it was Michigan. There was a neighborhood that was kind of run down. Not a lot. And the people that lived there had lived there for literally generations. We're talking 2 or 3 generations in a house. Children, grandchildren, great grandchildren were growing up in that house. And the city wanted to, was in cahoots with a development agent, and they wanted to have this because it was all, in essence, seashore-based neighborhood. The seashore went around them, and some of the backyards faced it but weren't on it, and they wanted to pull all that stuff out and build up high rises and that kind of stuff. And they got banks involved to foreclose on homes, to put blight. The city called blight on the neighborhood, which means in essence they can roll in with bulldozers and tear the houses down. They tried to buy the properties originally, and the people that lived there were like, no, this is my great grandmother's home, I'm not going anywhere. And the city didn't agree with that, and so they did tear it down. Almost all the houses were torn down, and some construction had been completed. New construction had been completed before federal court jumped in and stopped them. But
Yeah.
People had lost
Yeah.
homes that were, no lie, generational.
Yeah, and I'm actually a big supporter of eminent domain. I would say overall.
There's a surprise.
Yeah, but I'm also like, not it's also been used against people of in neighborhoods of color, in the past, and to horrible, as that you were just saying, to extents, where people lost not just their homes but their livelihoods and everything like that as well.
Yep.
So in that sense, and that's the double-edged sword of
Eminent
government
domain.
and the Constitution. Because depending on who the government is, what's going on. You're talking 80 years ago. That probably, and you're not a person who's a person of color, probably not going to go out well for you.
Right.
So
yeah, and that guy down in Prunedale, same thing,
Yep.
eminent domain.
Yeah.
He just had the money to fight it long term.
Yeah. So, but there's I in general, I'll support eminent domain, but it's all, I would say it's all depending case by case. So
I was gonna say I don't hate eminent domain because they still have to go through the Fifth Amendment for the most part, unless you're
you hate
dirty
the idea
caught
of
down.
eminent
Sorry,
domain.
one more time.
You hate the idea of eminent domain.
No, that's just it. I don't hate the idea of eminent domain because of the Fifth Amendment, because of the limitations of the Fifth by the Fifth Amendment. But I hate that it can be perverted easily without, like I said, the people in Detroit are out. I think it was a suburb of Detroit. Were out of home before they could do anything about it. So they were screwed.
And not necessarily just compensated necessarily either.
Right, exactly. Well, see, and that was the thing. When they turned to blight, there was no compensation for the homes. You couldn't sell that because it was under blight. Yeah. They didn't have to offer you any money because it was under blight. It was going to fall down on its own pretty soon anyway. Yeah,
and that's kind of like the same thing too. I was saying, that you're right. It can be perverted. You got the government, private industry. Right. basically kind of controlling the public interest. So,
absolutely.
And that can be good and not necessarily good. So it's, and I kind of have mixed feelings about that.
Yeah, I have my source is Cornell Law, and I'll put the link in here in the description box below. If you'll do us a favor, hit that, smash that like button, sign up, hit that bell notification so you get all of our shows. I haven't done any push-ups in like week and a half. Dude, this is killing me. And really? I get to do this side next week. So I've pretty much decided to write off March, which sucks. But I think I got 200. No, I got 350 in. So every time I try to do a push-up, it feels like there's a big freaking dwarf in there with a big freaking hammer trying to get out. It's just it gives me a headache. It gives me a migraine basically, and so I'm gonna wait till this kind of settles down, and I'll get back to him in April. Yeah.
So that's the end of the show. We're done. We covered all causes, all the 5 clauses. So.
I think we did, yeah, which is impressive for us. And we only went off on a couple of really tiny tangents. We were able to stick to it. So hey, we're getting better. Send this to your friends. Put it on your Facebook page. Whatever we can do to help us, that we appreciate it. We really do. We love you all. Couldn't do this without you because nobody else would watch it, right? Anyway, thank you so much. You guys have a great night or morning whenever you're watching this. Just have a good day. Be nice. Be kind to others. Peace, love, and soul. See ya!
Well, I'm Donovan, and John's here with us today. Thank you for joining us for the free exchange of ideas, and we'll see you next time on the next show. See ya!